Get ready for the dictation. Ready? 1, 2, 3, start. The present writ petition is filed to declare the proceedings dated 13/6/2025 of the fourth respondent as illegal and arbitrary and direct the respondent authorities to pay rupees 3,57,371 to the petitioner with interest at 12% per annum as expeditiously as possible, preferably within a period of 2 weeks. The facts leading to filing of the present writ petition are as follows. The petitioner had joined the respondent corporation as contingent watchman on 2/7/1977 in the government office Vijayawada, and his services were regularized with effect from 1/4/1981. On attaining the age of superannuation, that is 60 years, the petitioner had retired from service on 29/2/2016. At the time of retirement, the respondent corporation had paid the retirement benefits towards gratuity, GPF, and annual leave encashment short of above said amount. Though no information was initially given to the petitioner as to why the amount was withheld, eventually the impugned proceedings were issued on 13/6/2025, stating that the said amount was recovered towards excess pay and allowance on account of wrong pay fixation. Learned Standing Counsel, appearing for the respondents, would contend that the present writ petition is filed after a long lapse of 10 years and therefore the same cannot be entertained. Heard the respective counsel. It is to be noted that the petitioner had retired from service in the year 2016, and it is not the case of the respondent corporation that the petitioner had influenced in making wrong pay fixation. The Honorable Apex Court, in several judgments, has held that recovery should not be affected from the employees. In view of the above conclusion of the Apex Court, in catena of judgments, the recovery from the retired employees or the individuals who are due to retire within 1 year is impermissible. The same principle was reiterated by the Honorable Apex Court in several judgments. The petitioner's case clearly fits under the aforementioned category. Therefore, the impugned recovery by the respondents towards excess pay and allowance due to wrong pay fixation cannot be sustained. The contention of the Learned Standing Counsel, appearing for the respondents with regard to delay, is misconceived, considering the categorical judgment of the Honorable Apex Court and the retention of the money being in contravention of the judgment of the Honorable Apex Court. The delay would not be material to reject the case of the petitioner. Accordingly, the writ petition is allowed and the respondent authorities are directed to pay a sum of rupees 3,57,375 to the petitioner with interest at 7.5% per annum within a period of 3 months. The present civil reason petition are filed questioning the common order dated 4/1/2022 passed by the jurisdictional court. The petitioner is the plaintiff. A suit was filed claiming certain amounts due from the defendants in relation to execution of work dated 28/2/2009. After the evidence of the plaintiff, defendant filed his chief affidavit and the case was posted for cross-examination on 17/12/2021. On that day, the counsel for the petitioner did not attend the court, and consequently, after recording the presence of the defendant, the trial court closed the evidence and posted the suit for arguments. Thereafter, the petitioner filed the above applications to reopen the case by recalling for further cross-examination. In the affidavit filed by the petitioner, it was pleaded at para number 4 that the counsel for the petitioner was attending another court at Gudur on that day and could not present himself to cross-examine. The trial court dismissed the said application on the ground that the explanation offered by the petitioner was not germane. Hence, the present civil revision petitions are filed. Heard the learned counsel for the petitioner. There is no appearance for the respondents even though notice was served on them. The reason given by the petitioner that his counsel was held up in Gudur court cannot be considered as a valid explanation for his absence to conduct cross-examination. The defendant, being a government official, having come to the court, priority should have been given for cross-examination. Therefore, the explanation offered by the petitioner cannot be sustained. However, considering that the suit is for recovery of amounts for the works said to have been done by the petitioner, notwithstanding the explanation given by the petitioner, one opportunity should be given to the petitioner to cross-examine the defendant to establish his case. Therefore, the order of the trial court is liable to be set aside. Accordingly, the civil revision petition is allowed. The trial court shall fix a date, on which date the petitioner shall ensure that the defendant is cross-examined. Further, as the cause of delay is on account of laches of the petitioner, cost of rupees 10,000 shall be paid by defendant by the petitioner. Stop.